So everybody, welcome. Today is Tuesday, November 9th, 2021. You are participating in a webinar, a Fair Housing Accessibility Seminar. And this is being hosted by the City of Shaker Heights by our Fair Housing Review Board. We also have our partner organization with us today. We have Tanisha on. Tanisha Hunter is with the Fair Housing Center for Rights and Responsibilities. And we also have special guests from Maximum Accessible Housing of Ohio. We have Mara Lane and Beth Glass. The City of Shaker Heights has a Fair Housing Review Board consisting of 5 members, and they are dedicated to ensuring equal housing opportunity for all. And part of their mission includes enforcement as well as education and outreach. The Fair Housing Office is actually located in the law department of the City of Shaker Heights. Individuals who believe that their fair housing rights have been violated can file a complaint with our office. We conduct an investigation. We try to, from the beginning, to resolve, perhaps through conciliation. We do conduct an investigation, and sometimes it does result in a conciliation agreement. Other times, if we can't come to some resolution, it may result in an administrative hearing or even a court filing. We also strive to bring the public timely, relevant educational programs such as this one. And we have a wide audience that we serve. We serve renters, property managers, real estate agents, home seekers, anybody who has an interest in better understanding the rights and responsibilities under the fair housing laws, or how they can assist others with those same rights and responsibilities. Today's program, you're going to hear from these 2 different advocacy organizations. And you'll first hear from the Fair Housing Center, and you'll get a firm grounding and understanding in basic fair housing law with a focus on persons with disabilities and why accessibility is a fair housing issue and why we should care. Next, we'll turn it over to Maximum Accessible Housing of Ohio, and they'll delve a little bit deeper into the topic, giving us some real world examples and real useful specific examples that hopefully you can take back and incorporate into your situations or in your workplace as it's appropriate. And we'll also include some ADA issues to round out the evening. At this point, I'm going to turn it over to our law director, Bill Gruber. Hi, Bill.
Hi. Oh, so I've done the introduction for me. Thank you very much. I'm Bill Gruber, the law director for the City of Shaker Heights and Fair Housing Administrator. Welcome to everyone who is hearing this live or on recording. And I just wanted to express how important we feel at the City of Shaker Heights and with our Fair Housing Review Board, the issue of accessibility is, and particularly for elected officials and planning commission members, zoning officials, architectural board of review, or landmark commission members and others in appointed or elected positions that are looking at building codes and doing proposals for new housing, renovated housing, and additions to homes and other work that's being done throughout our communities. The issue of accessibility, visitability, and remaining in place for especially the elderly who would like to stay in their communities as they grow older is a very important issue, especially for an inner-ring suburb like Shaker Heights that has housing. I'm sitting in a 104-year-old home in Shaker Heights, and there are many others that are older and getting close to 100 years old. And so we have a lot of housing that was not built with accessibility in mind at all. But we see people making improvements to their housing every day at the city, coming before our boards and adding additions and all sorts of new features to their housing. We see apartment building owners doing improvements, condos doing improvements. But what we don't see very often are elected officials and appointed officials to these boards and commissions asking the question, have you considered accessibility features when you are planning these improvements, because that's the time to do them. So we're not looking at necessarily passing laws that require existing homes and apartments and condos to put in these features, but we are looking for people to be encouraged to do them and find ways to encourage them to do these kinds of improvements and additions to their properties as they are investing money in them already, because that's as I said, the time to do them. So I hope that we can encourage board members, elected officials to inquire about these, ask about architects, are you including these features when they can easily do so? I don't think a lot of them even think about it. Even people coming in to say they want to age in place don't necessarily think about what's going to be necessary 10, 20 years from now when they are really aging in place and need those accessibility features, which I think would improve the housing throughout the city. We could look also at incentives like reduced or different permit fees for those who are doing improvements. So we'd love to hear suggestions and ideas, and we are trying to think outside the box to do this, and we encourage other elected officials and appointed officials to boards and commissions around the Northeast Ohio to think the same way. So thanks very much for attending, and I hope that we all learn a lot today.
Okay, great. So thank you again. My name is Tanisha Hunter with the Fair Housing Center for Rights and Research. I am the Director of Education and Outreach at the Fair Housing Center. I want to first start by saying that while I work for the Fair Housing Center and talk about fair housing law, I am not an attorney myself, and we do not have any attorneys on staff. And so this presentation is for informational purposes. For any specific legal questions, we do advise that you consult an attorney. So about the Fair Housing Center. So our organization started in 1983 as a grassroots organization where different fair housing advocates would come together to talk about different fair housing issues. Since then, we have become a more focused fair housing agency whose mission is to protect and expand fair housing rights, eliminate housing discrimination, and promote integrated communities. And we drive this mission through some core services, which includes direct advocacy. Now, that may be, for example, providing assistance to victims of housing discrimination, as well as proposing and enforcing effective fair housing laws. We also do complaint investigations. Our advocates are available to assist victims of housing discrimination and offers free assistance to victims in the administrative complaint process. Enforcement, this may include monitoring rental, sales, and lending markets for discriminatory practices. Research. Our research team is phenomenal. If you have never had the opportunity to look at some of our different publications, I invite you all to at some point go to our website and look at our different publications. Our research team produces a variety of maps, reports, and other publications that examine fair housing and fair lending discriminatory practices and barriers to fair housing in the region. And then education and outreach. So just like today, going out into the community, partnering with different municipalities and organizations to ensure that we are making sure that folks know what their fair housing rights are. So first, I'll talk a little bit about the birth of fair housing, right? So throughout history, certain populations have continuously experienced barriers to housing. So the Chicago Freedom Movement, also known as the Open Housing Movement, was one of the most ambitious civil rights mobilizations in the North. And the focus was really on housing, education, transportation, and jobs. So through marches, community organizing, and nonviolent demands of the city of Chicago, the movement sought to end residential segregation. So Dr. Martin Luther King had been doing a lot of work in the South to combat racial residential segregation. And when he came to Chicago, he found that Chicago was no more integrated than in some of the Southern cities that he was working in. So this movement was a part of a constellation of forces that would actually lead to the passage of the Fair Housing Act on April 11th, 1968. So Dr. Martin Luther King was assassinated on April 4th, 1968. And prior to that, Congress really wanted to pass a fair housing law, but it never garnered enough support. And so after Dr. Martin Luther King's assassination, President Lyndon B. Johnson signed the Fair Housing Act on April 11th, 1968, just 7 days after Martin Luther King was assassinated, as a tribute and memorial to his life's work. So fair housing, applicable laws. So fair housing is a civil right protected by federal, state, and local laws. So just like zoning, building, and occupancy codes, fair housing is not an option. It's a law and has to be followed just as those other codes have to be followed as well. Fair housing law is enforced by HUD, the Ohio Civil Rights Commission, the Department of Justice, and then local fair housing agencies, such as Lisa discussed with the city of Shaker, as well as private lawsuits in federal or state courts. So we're going to talk about a little bit, give just a brief history lesson, talk about applicable laws when it comes to housing and disability rights. So first, we'll talk about, of course, Title 8 of the Civil Rights Act of 1968, also known as the Fair Housing Act, in which we talked about it being passed on April 11th, 1968. But the law prohibits discrimination in most housing-related transactions. When the law was first signed, it prohibited discrimination on the basis of race, color, religion, and national origin. Sex was added in 1974, and then the Fair Housing Act was amended in 1988. Then the Architectural Barriers Act of 1968. And so the ABA, this law requires that buildings or facilities that were designed, built, or altered with federal dollars or leased by federal agencies after August 12, 1968, be accessible. Facilities that predate that law generally are not covered, but alterations or leases undertaken after the law has took place can trigger coverage. Then we have Section 504 of the 1973 Rehabilitation Act, and we will talk about this more just a little bit further down into the presentation, but this was the first disability civil rights law to be enacted in the United States. It prohibits discrimination against people with disabilities in programs that receive federal financial assistance and really essentially set the stage for the Americans with Disabilities Act to be enacted. Then we have the Fair Housing Amendments Act of 1988, which was signed into law on September 13th, 1988. And again, this act amends Title 8 of the Civil Rights Act of 1968, also known as the Fair Housing Act, which prohibits discrimination in housing sales, rentals, or financing, and extends its protections to persons with disabilities, as well as families with children. We'll talk a little bit more about protected classes further down into the presentation. Then the Americans with Disabilities Act. This was signed into law on July 26, 1990 by President George Bush. The ADA is one of America's most comprehensive pieces of civil rights legislation that prohibits discrimination and guarantees that people with disabilities have the same opportunities as everyone else to participate in public accommodations, state and local government, transportation, employment. The Housing for Older Persons Act of 1995 amends the Fair Housing Act to include, to allow certain senior housing to exclude children. And we'll talk a little bit about this more when I talk about protected classes. And then we have state and local laws, right? So many many cities and towns and municipalities have laws in place that where the buildings must have certain codes to get, permits. But builders, one of the key things here is that builders shouldn't just rely on building codes to meet compliance with the Fair Housing Act's design and construction requirements. And again, we'll talk about that. We're going to dive deep into that further down into the presentation. So some of the Fair Housing Act's goals, one, of course, to eliminate housing discrimination. So I talked about how many populations have barriers to accessing housing, and so eliminate housing discrimination, but then also to promote residential integration and undo the effects of prior discriminatory policies and practices. And this is known as affirmatively furthering fair housing, or AFA. So what property is covered under the Fair Housing Act? Residences and vacant land for residences. Any building, structure, or portion thereof which is occupied as, or designed or intended for occupancy as, a residence by one or more families, and any vacant land which is offered for sale or lease for the construction or location thereon of any such building, structure, or portion thereof. Okay. So let me give you some examples of what that really means, right? So what property is covered? Some quick examples: homes, apartments, condos, manufactured mobile homes, nursing home, assisted living facilities, residential recovery housing, transitional housing, dorm rooms, extended stay hotels, timeshares, and then even vacant land intended for residential construction. The federal fair housing law does provide some exemptions. But it's important to note that Ohio doesn't recognize some of the exemptions that federal law does. Ohio's fair housing law then is considered to be much broader than the federal fair housing law, making just about all housing covered under the state of Ohio. So now that we've talked about what property is covered, let's talk about protected classes. So on the federal level, we have 7 protected classes that I mentioned before when we talked about applicable laws, right? So we have race, which is how one might identify, right? Whether you identify as white, Black, Asian. Then we have color, which can be intra-race, right? That can mean that perhaps a light-skinned Black person is discriminating against a dark-skinned Black person. National origin, which includes birthplace, language, and culture. Religion. Sex, which also includes, sexual orientation and gender identity. In 2020, President Biden signed an executive order that explicitly lists sexual orientation and gender identity under the basis of sex under protected classes. Prior to that, while it wasn't explicitly listed, case law had shown that sexual orientation and gender identity were covered under the basis of sex. However, now, because of President Biden's executive order, it is explicitly listed. Then we have familial status and disability. So one thing to note is that all of the other protected classes that I just previously mentioned are regardless of, right? You are protected regardless of your race, regardless of the color of your skin, regardless of your sex. However, disability and familial status are affirmative protections and have very specific definitions. And so familial status is includes families with children under the age of 18, also parents or another person who has legal custody of them, and then also a designee of a parent or a person having such custody, such as someone adopting or a foster parent, and also includes pregnant individuals as well. Disability also has a specific definition, which we'll talk about a little bit more in depth. And then, so that's on the federal level, those 7 protected classes. Then in Ohio, we have some additional protections. In Ohio, we have ancestry, which is a somewhat more broader term than national origin, and military status as protected classes. Then furthermore, you want to look at additional protected classes that different municipalities have. So Shaker Heights has some additional protected classes. So even prior to President Biden signing that executive order, including sexual orientation and gender identity as a protected class under the basis of sex, the city of Shaker Heights had already included that as additional protected classes in their ordinance. But then other local ordinances may have some additional protected classes, which might include age, marital status, parental status, source of income, creed, ethnic group, occupation, physical characteristics, and then even association with a protected class. So a little bit more about that definition for disability. A person is protected as a person with a disability under fair housing law if they meet one or more of the following conditions. So a physical and or mental impairment which substantially limits one or more major life activities. And so when we talk about major life activities, we're thinking about functions such as caring for oneself, walking, seeing, hearing, speaking, breathing, learning, working. Then also a record of having such impairment. And so this is when perhaps a person has a history or has maybe even perhaps been misclassified as having a mental or physical impairment that substantially limits one or more major life activities. Then we have being regarded as having such impairment. And so this is when a person may have a physical or mental impairment that does not substantially limit one or more major life activities, but they're treated by another person as such. This is really about how someone perceives you. So, it may be how, a person may look a certain way and a person may assume or perceive that person to have a substantial disability. And also includes people associated with or residing with person meeting definition. So some further examples of which disabilities are covered. So we have chronic mental illness, hearing, mobility, and visual impairments, cancer, AIDS, HIV, developmental disabilities, and then also alcoholism or past drug abuse. The Fair Housing Act, however, does not protect current illegal drug users or anyone who poses a direct threat to the health and safety of others or causes substantial physical damage to the property. So now that we have talked about covered property and protected classes, now we'll talk about some of the prohibited acts under the Fair Housing Law. So what exactly is housing discrimination? Well, it's the refusal to sell, rent, negotiate, or otherwise make unavailable or deny a dwelling. So let me give you some quick examples. So say, for instance, a housing provider refuses to rent to a family because they have a child with autism. Or say a housing provider, won't show an apartment to a person because they notice that that person has an accessible parking placard in their car. Make housing unavailable. So an example of that may be, perhaps a person is being restricted to a certain area of an apartment complex or a unit because of their disability. Then perhaps not allowing individuals who have service animals on upstairs units because they're afraid of the noise or because someone on the down unit might complain. Then discriminate in the terms, conditions, or privileges of sale or rental of a dwelling or in the provision of services or facilities. So some quick examples of that. So say, for instance, requiring a person who uses a motorized wheelchair to pay a higher security deposit than everyone else because, maybe the housing provider is afraid that their floors are going to get scratched up or something to that nature. Then, perhaps even allowing or not allowing someone with a service animal to use the laundry facilities, or not allowing a person with a seizure disorder to use the recreation facilities. Then we also have make, print, or publish any notice, statement, or ad indicating a preference or a limitation based on a protected class. So, in advertising, where you might see something that says like no Social Security disability income, or perhaps even no wheelchairs allowed. These would all constitute discriminatory acts under the Fair Housing Law. Furthermore, we have misrepresenting availability. So, when a person maybe perhaps in a wheelchair comes up to ask for an apartment and they tell them there are no units available, and then, a person who isn't in a wheelchair comes up and they tell them that, oh, there's 5 units available. Denying a reasonable accommodation or modification request, which we'll talk about in just a little bit here, and then intimidating, threatening, interfering with, or otherwise retaliating against a person who is exercising their fair housing right. And we see this a lot, someone may be makes a reasonable accommodation request or, files a formal complaint. And then while the housing provider may not have intentionally, done something wrong, they get upset because a complaint is filed or because the request is being made. And so then they turn around and try to evict that person. So if it wasn't a fair housing violation before, it definitely is one now, because you're retaliating against that person because they're exercising their fair housing right. So now we will go into additional protections for people with disabilities. So again, the Fair Housing Act was amended in 1988 to include disability as a protection, and that also brought in some additional protections. So according to the 2020 National Fair Housing Alliance annual term report, complaints alleging discrimination because of disability continue to account for the largest number of complaints at 58.90%. So almost 59% of complaints are on the basis of disability. And likely, no matter where you are in the United States, disability is likely the #1 complaint that local fair housing agencies, HUD, are receiving. So additional protection. So the Fair Housing Act is designed to ensure that everyone is treated equally in the process of obtaining and maintaining housing. People with disabilities are afforded additional protections to ensure equal enjoyment of their home. Housing providers are required to grant reasonable accommodations and reasonable modifications to tenants with disabilities. So what are reasonable accommodations and modifications? Well, a reasonable accommodation is a change in policy, right? This might be a change in the policies or practices that govern the residents. Then a reasonable modification is a physical change to the property. And again, we'll go a little bit further in depth here. So a reasonable accommodation is a change, again, in the policies and procedures that govern the residents. The accommodation must be related to the person's disability, cannot cause an undue financial and administrative burden, and I emphasize and, not or, and, cannot be a fundamental alteration of the normal services provision. The housing provider must grant the accommodation if it meets these criteria. So what are some examples of reasonable accommodations? Allowing a service animal despite a no pet policy. Informing others, whether that be a social worker, family members, of new policies and procedures for the tenant. Allowing a non-tenant to use the laundry room if that person is unable to do their laundry on their own, allowing someone else to do so. Moving from one unit to another without a fee. Reserved parking spaces. Allowing a live-in aid. Changing the rent due date. So perhaps a person receives their Social Security disability check on the 3rd Wednesday of the month, and the rent is typically collected on the 1st, allowing that person to change their rent due date so that it falls on the day they receive their income. And then also utilizing the Ohio Relay Service. A little bit more on assistance animals. As reasonable accommodations. So it's important to note that the Americans with Disabilities Act, the ADA, and the Fair Housing Act do not have the same definition of assistance animals. Fair housing law allows assistance animals for reasonable accommodations in housing and order a broader definition. So there are 2 types of assistance animals. One is a service animal, and these animals might help with specific tasks, such as guiding an individual who is visually impaired, fetching items, or alerting a hearing impaired person to sounds. Then an emotional support animal might help relieve depression, anxiety, or stress-induced pain. A person could need an emotional support animal for a variety of reasons, but there is no training requirement or specific animal defined within the Fair Housing Act. A person might have an emotional support ferret or an emotional support, bird. People with disabilities, again, can need an animal for various reasons. So it's just important to note that assistance animals are not considered as pets. So if if a housing provider has a no pet policy, that housing provider would have to allow for assistance animal despite that no pet policy, and then can't be charged extra for assistance animals as well. And so reasonable modifications. A reasonable modification is a physical change to the interior of a tenant's own unit or to the common use areas that allows the person full enjoyment of the housing. So the tenant is responsible for requesting the modification from the housing provider. This can be a huge misconception for housing providers at times, where they think that if a reasonable modification is made, that they have to supply that reasonable modification and even pay for it. But that's not the case. The housing provider, well, in some circumstances that might be the case, but majority of them it's not. The housing provider is just, their responsibility is to grant the reasonable modification. The modification, just as with the reasonable accommodation, must be related to the person's disability, cannot cause an undue financial and administrative burden, and cannot be a fundamental alteration of the normal service and provisions. So to give a quick example of what that might look like as far as a reasonable accommodation, that change in policy. So say, for instance, a person has some mobility impairments, and in order to empty their trash, they have to go out of their apartment complex really far away to where the dumpster is in order to empty their trash. And with their mobility impairments, they're not able to do so. So they might make a reasonable accommodation request to the housing provider to have a home maintenance person or the maintenance staff come into their home every day to take their trash out and take it to the dumpster. That might be unreasonable for that housing provider, as it will cause an undue financial and administrative burden. Say, for instance, their maintenance staff is only part-time, right? However, so if they would have to deny the reasonable accommodation request, they still need to engage in an interactive process with that tenant to ensure that their needs are being met. So perhaps instead of a maintenance staff coming in every day to empty the trash, they, find a larger bin that can be set outside at the end of the hallway where that person with the mobility impairment is able to get to, so that they can empty their trash into that every day. And then maybe the maintenance staff can empty that once a week, right? That's an alternative to their reasonable accommodation request. So back to reasonable modifications, some quick examples: widening doorways, installing grab bars, lowering the heights of kitchen cabinets, installing a ramp, installing automatic water shutoffs, installing or removing carpeting, lowering or raising heights of switch outlets or thermostats, and then installing levered door handles. Requesting a reasonable modification or accommodation, a tenant can ask for more than one reasonable accommodation or modification. It may be necessary for a person with a disability to have more than one reasonable accommodation or modification in order to equally use and enjoy a dwelling. And I often give the example, or just want to point out, that when people are making requests for reasonable accommodations or modifications, it's because they are unable to equally enjoy that unit, right? So something is lacking where they are not able to enjoy the dwelling equally. So that might be, they can't take a bath because they don't have grab bars, or they may not be able to go pay their rent because it falls on a different day that they receive their income. A tenant can also ask for the reasonable accommodation or modification at any point during occupancy. It doesn't have to be when the tenant first signs their lease. It can be at any point during the application process, leasing process, or while occupying the unit. It may be that a tenant requires a disability during their tenancy in a unit, and therefore their needs may be different from when they first moved in. A housing provider can ask for proof of disability if it's not readily apparent, ask for proof that the person with a disability requires the requested accommodation because of their disability, So this can be a letter from a medical or social service provider or someone with knowledge of disability. A housing provider cannot ask questions about the nature or extent of the person's disability. They only need to know that the person has a covered disability under the Fair Housing Act. They don't have to a person doesn't have to get into the specifics of what their, personal diagnosis is. A housing provider also cannot require the person with a disability to disclose their diagnosis, ask for medical records, ask how long a person has had their disability, and again, charge fees for the reasonable accommodations. Paying for a reasonable modification. A tenant is usually responsible for paying for reasonable modifications. There are two instances when a housing provider may be required to pay for the modification. That's if the building received federal financial assistance. We'll talk about that a little bit more in section 504. And then also if the building was built for first occupancy after March 13, 1991, and the modification is covered under new construction requirements, which I'll talk about just shortly here as well. So reasonable accommodations and modifications in subsidized housing. So public housing and project-based housing are buildings that receive federal financial assistance. And when the unit is funded using federal financial assistance, the reasonable modifications are paid for by the housing provider. However, funding for housing choice voucher recipients, the housing choice voucher, that funding is connected to the person and not the housing unit. So therefore, a person utilizing the housing choice voucher would have to still pay for their reasonable modification. So a quick rundown of the process for requesting a reasonable accommodation and modification. The tenant makes the request, and requests can be made at any time. Document all reasonable accommodation and modification requests, including any verbal ones. A housing provider must respond in a timely manner. And again, that's important because someone is lacking something in that home and they can't enjoy that dwelling equally. So it must be responded to in a timely manner. And then the housing provider can ask for documentation if the disability is not known or apparent, or if the connection to the disability is unclear, right? So I mean, a person asking for a ramp in a wheelchair, that's a pretty appearance reasonable modification request. But perhaps someone requesting a reasonable accommodation of adding some additional locks to the door because they have an anxiety disorder, that may not be readily apparent. Again, documentation can be provided by a medical, social service, or mental health professional, or someone with intimate knowledge of a person's disability. The letter is not required to disclose, again, the diagnosis, nature or extent of that person's disability, but can include information that the person feels comfortable sharing. That letter would only need to state that that person has a covered disability that impacts one or more major life activities that's covered by the Fair Housing Act, and the requested reasonable accommodation or modification is needed due to their disability. Before I go into new construction requirements, wanting to say a couple more things about reasonable modification. One is that escrow accounts may be asked to restore the unit by the housing provider. So say for instance, after the tenant has ended their tenancy and the housing provider wants the unit to be restored, they can ask for an escrow account to be established in order to ensure that there is money available in order to do that. And then a housing provider also can require that the work be done in a workmanlike manner so that, permits are pulled and there are contractors doing the actual work. Okay, sorry to skip around like that. Now we're going to get into new construction requirements. And so on March 6, 1991, the Department of Housing and Urban Development published final fair housing accessibility guidelines. These guidelines provide builders and developers with technical guidance on how to comply with accessibility requirements of the Fair Housing Amendments Act of 1988. That are applicable to certain multifamily dwellings designed and constructed for first occupancy after March 13th, 1991. So again, these new construction requirements, covers multifamily dwellings, 4 or more units connected. If there is an elevator, all units must comply. If there is no elevator, only the ground floor units must comply. Again, this is built for first occupancy on or after March 13, 1991, applies regardless of public or private funding, and then applies to all covered dwellings under the Fair Housing Act that has these applicable requirements, as I just mentioned. So there are some exemptions under these new construction requirements. Exemptions might include detached single-family homes, duplexes, triplexes, and then townhomes are exempt if the finished living space has more than 1 floor with no elevator. So if the townhome is a multi-story home, then it will be exempt as well. So I'll give a quick visual, and this is from the Fair Housing Act design guidelines. But a quick visual of these requirements and an example of covered and exempt properties, right? So you have this unit that has this 4 or more connected. We see in this very first unit here, it's a ground floor unit, but it has a finished basement with living space. So this actually makes this a 2-story dwelling unit. And so this would then not be covered under the new construction requirements, okay? Just to the right then, we have just a single-story unit, again, in this multifamily dwelling with this 4 or more connected. So this is actually a covered property. Then furthermore, we have these 2 units that are two-story units. They then would not be covered under the new construction requirements because they're the multi-story. So now to get a little bit further in depth about the 7 required accessibility features. We have accessible entrance on accessible route. Public common areas are accessible, usable doors, accessible route into and through the unit, switches, outlets, thermostats, etc., and accessible locations, reinforced walls in the bathrooms, and then usable kitchens and baths. And I'll touch base on each of these just shortly here. Okay, so accessible entrance on an accessible route. So covered multifamily dwellings must have at least 1 building entrance on an accessible route unless it's impractical to do so because of, the setup of the terrain or if there are impractical characteristics on the site. At least 1 accessible route must be provided to the accessible building entrance, and that accessible route must connect to either parking lots or pedestrian arrival points. So sidewalks need to have clearance of 36 inches. And that's so to allow a person in a wheelchair to be able to navigate that sidewalk. There can't be any no block access or protruding objects getting in the way of that 36 inches. Low or no threshold, and then clear maneuvering space inside and outside the door. So one thing I do want to share, and I want you to please keep note of this as we talk about the 7 accessibility features of the new construction requirements, is that these provide the minimum standard, right? And so Mara and Beth will talk a little bit more about what it is to expand and what it will look like for more full accessibility, but these provide the minimum standard. So even like looking at this picture here, you see it has this low threshold on the curb to allow a person in a wheelchair to get up on that sidewalk. But there's a huge problem here, right? If this white car is parked right here and a person in a wheelchair pulls in, how are they going to get out outside of their car, right? It needs to be an access aisle here. So again, these accessibility requirements just provide the minimum standards. And like I said, Beth and Mara will talk more on the expanding those requirements for full accessibility. Public common areas accessible. So public and common use areas must be accessible and they must be on an accessible route. So any amenities that a property might offer, all features must be on accessible routes, and common areas and might include rental and management offices, mailbox kiosks, swimming pools, tennis courts, clubhouses, garage dumpsters, and playgrounds. And so this requirement also establishes minimal levels of accessible parking. So if parking is provided at that property, I'll just go to a visual here. Proper signage needs to be in place. Striped access aisles, accessible parking spaces need to have curb ramps, and curb ramps need to be near accessible parking spaces. So again, we got a little blooper here, right? So we see this this accessible parking, got the proper signage here, have a curb ramp, but there are, again, no access aisles, right? No access aisles for individuals to have space to be able to get out their cars. Usable doors. So doors within individual dwelling units that are intended for user passage must have a clear opening, right? So doors that are part of an accessible route in public and common use areas and that are primary entrance doors to covered dwelling units must have that minimum 32-inch nominal clear opening. And so that's a little bit under 32 inches, which is what that nominal is. So handles, locks, latches must be operable without twisting. So, being able to open a door with just one hand. Thresholds into the doors need to be 3/4 inch or less. When we talk about push or pull force, interior hinge doors shouldn't take more than about 5 pounds of pressure to pull or pull open. And so a quick example about the orbital door. So in older homes, those prior to the new construction requirements, or just older homes in general, you'll see these orbital door handles, right? But they're not accessible. And so replacing them with lever door handles. All right. Then we have accessible route into and through the dwelling unit. So is the entrance to the apartment wide enough to accommodate a wheelchair? Can a person using a wheelchair get from one room to another without encountering any narrow doorways or high thresholds, right? So just as we talked about with the exterior, how the sidewalks need to have that 36-inch clearance, hallways must have the minimum clearance of 36 inches as well. And then there may be small abrupt changes in levels that typically occur at floor material changes and at door thresholds within the unit, right? But within the interior of the dwelling unit, thresholds should not be used, or they should be rather thin and installed flush with the flooring, right? So thresholds shouldn't be used, and then if there are thresholds, they should be very thin and flush with the rest of the flooring, okay? Then exterior slope ramps should be 1 to 12-inch max, so that's 1 inch up and 12 inches wide. So we see this example here, right? This, of course, just visibly, you can tell is not accessible. Looks like a slide rather than an actual slope. So it's a quick example there. Okay, so switches, outlets, thermostats, in accessible locations. So what's not covered under this requirements are controls on movable appliances like stoves, controls on range hoods, controls on garbage disposals, special use walls or outlets like those that might be designed for like a refrigerator or a stove, and then circuit breaker panels, and then telephone and television jacks. So with these requirements, and this is again from the design manual, requires that outlets be placed no lower than 15 inches above the finished floor, And then switches, thermostats not located over countertops or other obstructions must be no higher than 48 inches above the finished floor. So that's the max. And then again, it may be some exceptions for special use outlets like floor outlets. Reinforced walls and bathrooms. So requires that bathrooms and covered units have reinforcements installed in the walls for later addition of grab bars. So this does not mean that grab bars necessarily have to be installed, because again, it's just a minimum, but reinforcement should be in place so that when someone does need to install a grab bar in the future, that they're not going through the wall by doing so. So reinforcements are required where the grab bars will be placed around toilets, tubs, showers. Reinforcements are not required in powder rooms. Then lastly, usable kitchens and baths. So kitchens and bathrooms must be designed and constructed so a person in a wheelchair can maneuver about the space and use fixtures and appliances. Again, minimum requirements. General requirements to create usable kitchens are a clear floor space at 30-inch by 48 at appliance and sinks. A minimum clearance of 40 inches must be provided between all opposing countertops, appliances, or walls. Turning and clearance requirements in U-shaped kitchens. Then we have general requirements to create usable bathrooms, clear floor space outside of the swing door. So a person in a wheelchair should be able to go into a bathroom and shut the door behind them, right? And be able to maneuver around within that bathroom. Clear floor space at fixtures, including lavatories, toilets, bathtubs, and showers. So in the context of thinking of this, can a person using a wheelchair easily access the sink using a parallel approach, right? If the kitchen is too small to accommodate a parallel approach, is there knee space below the sink to make it accessible? Can a person enter the bathroom and close that door behind them and have enough floor space? These are all things in consideration of the usable kitchens and bath. So just a quick example here, usable kitchen. But again, like I said, looking at the minimum standard and just looking at just one thing I just quickly noticed in here is that, it's still not completely accessible. And like I said, I'm sure Mara and Beth are going to show you some better examples. But just one quick thing you notice here is that, if a person is in a wheelchair, right, and these knobs on this stove here, they would have to reach over that, hot stove in order to turn the handles. So again, while the stove handles aren't necessarily covered, you still have to just always be thinking about what more can be done for accessibility. And we'll talk about a little bit more about why that's important at the end of the presentation. Then a usable bath. This picture though, however, is actually it's a better representation of accessible bath. So here we have the floors, the clear space for the sink. You've got a grab bar here next to the toilet. Grab bars in the shower is wide enough so that a person with a wheelchair can get in there. So this is a much more better example of accessible bath. I won't get into the specifications of specification A and B for usable baths. As you all may or may not know, this training within itself for accessible design features, we could do a whole day training just on accessible design features. So I'm trying to quickly give just some quick examples and a summary of these 7 accessibility features, but it goes much more further in depth. And I'll give some resources at the end that can provide some additional information. So new construction safe harbors. So ensure compliance with the design and construction requirements of the FHA Properties must comply with the Fair Housing Act accessibility guidelines or one of the HUD approved safe harbors into the design of a multifamily development. So on December 8th, 2020, HUD published a final rule adopting additional safe harbors that can be used to demonstrate compliance with the design and construction requirements of the FHA. I'll give a couple quick case examples and then round us out with section 504 and give us a conclusion. I'll try to kind of speed up a little bit. I know so that we can have time for Beth and Mara. So a couple quick examples of recent cases. So on March 30th, 2020, we have United States versus Fernando L. Sumza and company. The complaint filed alleged that the company and its affiliated entities were involved in the design and construction of 11 multifamily housing developments located in Puerto Rico. And all these properties were built using LIHTC, home, or USDA funds. So the principal violations at the properties included like a lack of accessible routes to many of the covered units and the public and common use areas due to like different steps being there, absence of curb cuts, vertical level changes, and even steep running and cross slopes. A lack of accessible routes into and through the dwelling units due to high thresholds, and then even narrow passageways and narrow doors were included in the design of these developments. And so the decision then, court was ordered to, for this company, a settlement fund of $150,000 to compensate the victims, a civil penalty of $10,000, and then even retrofits to alleged complaint barriers on the accessible routes in the public and common use areas and in the covered dwelling units at the properties. So, if individuals or companies are found to be in violation of the new construction requirements, the consequences can be exorbitant. I mean, the amount paid and the work needed to be done to restore and to retrofit the property. Another example, March 25th, 2020, United States versus Epcon Communities. The complaint alleged that the defendants failed to design and construct 32 condominium properties in Ohio in a manner that complied with FHA accessibility requirements. And so the corrections that the defendants had to take were to like the common use areas, including removing steps, replacing steep slopeways and walkways, and then also adding accessible routes from units to the amenities like their clubhouse, their swimming pool, and to provide accessible parking. The decision here was that this company had to pay up to $2 million to correct inaccessible features in the common areas of the properties and within individual units. Then lastly here, United States versus the Pendergraph companies. The complaint alleged that defendants, the owners, developers, and builders of multifamily housing developments in North Carolina and South Carolina discriminated against persons with disabilities in violation of the FHA and ADA by failing to design and construct LIHTC funded covered multifamily dwellings in a manner that made them accessible to persons with disabilities. So again, the decision here, this is the proposed consent order. It required the defendants to make extensive retrofits to remove accessibility barriers in the housing units, and then also to pay $275,000 into a settlement fund to compensate individuals harmed by the inaccessible housing, and also to pay a civil penalty of $25,000 to the United States. So not following the guidelines can lead to some extensive consequences. So that's why it's very important to ensure that guidelines are being followed. Real quick, I'll go over section 504 and then end us with a conclusion to make way for Mara and Beth's presentation. So I talked a little bit about section 504 earlier. under the applicable laws, but Section 504 of the Rehabilitation Act of 1973 prohibits discrimination on the basis of disability in public and private programs and activities that receive federal financial assistance. Again, it was signed into law in 1973, but the laws didn't take effect until 1977. And so what you see here is pictures from some of the 504 sit-ins, because 4 years had went by and the law was still not being enforced. And so advocates, persons with disabilities, advocates, different groups did this sit-in to make awareness and so that the law could be actually enforced. It had been signed, but was not being enforced. So Section 504 states that no otherwise qualified individual with a disability in the United States, as defined in Section 705(20) of this title, shall, solely by reason of his or her disability, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, or under any program or activity conducted by any executive agency or by the United States Postal Service. So Section 504 requires that HUD enforce the right of individuals to live in federally subsidized housing or participate in any federally assisted program free from discrimination on the basis of disability. It also covers employees, and so covers employment discrimination based on disability and requires HUD and HUD assisted entities to make reasonable accommodations for the known physical or mental limitations of an employee or qualified applicant. So it covers all HUD programs except for its mortgage insurance and loan guarantee programs. So Section 504 covers employees of organizations covered by 504. Section 504 prohibits excluding or not providing people with disabilities access to participate in any service, program, or activity. So, this might look like, requiring a person with a disability in a complex or development to, accept a different or lesser service, accept service separate from others without disabilities. So, for example, a meeting is being held for individuals without disabilities, and then a separate meeting is going to be held for individuals with disabilities. Pay an added fee, meet different eligibility requirements, and then also forego any service or amenity available to others. So services and programs must be conducted in the most integrated setting appropriate. So housing provided to individuals with disabilities shouldn't be separate or unnecessarily segregated, which might include accessible units in a single elevator building should be located throughout the building and not just on the first floor. And then in projects having multiple buildings, accessible units also should be interspersed throughout these buildings and not clustered together. So for example, in housing for seniors and people with disabilities, persons with, mental disabilities or any other disability can't be just segregated on one wing, right? Or just in one building. So when a UFAS unit, the Uniform Federal Accessibility Standards unit, which is an extra accessible unit for a mobility impaired person, becomes available for occupancy, the housing provider must offer the unit first to a qualified individual with disability who's already in an accessible unit in the development or project. And so first the unit will be offered to somebody else with a disability who requires the accessibility features of the UFAS unit. And if the provider doesn't have somebody already waiting for that available unit, then the provider could go to the waiting list and offer that unit to the next available qualified individual with disabilities. So a provider might skip over people who don't need the UFAS unit to get to somebody who does, because these units are, few in number and they provide such significant life-changing accessibility features for the people who might need them. So HUD then really wants to prioritize folks who require those accessibility features. The Fair Housing Act requires private landlords to permit but not pay for reasonable modifications. However, recipients of federal financial assistance are subject to Section 504 and are required to both permit and pay for reasonable modifications. Again, private landlords who accept the Housing Choice Voucher program are not considered federal recipients, and so then the tenant then has to pay for those modifications. So a couple quick examples. A federally assisted housing provider has a no pets policy, right? A tenant who requires an emotional support animal for anxiety is allowed to have an assistance animal that helps relieve their anxiety so that they may enjoy the dwelling equally. Another example, a federally assisted housing provider has a policy of requiring tenants to pay on the first day of each month, right? So I did give this example earlier. A tenant who receives their disability income on the third Wednesday would then be allowed to change that date in order to be able to allow them to pay their rent on a day where they receive their income and not just on the day where the rent is typically, collected. And then the last example, a tenant maybe has a stroke and begins to use a wheelchair, right? The apartment has steps at the entrance and they need a ramp to enter the unit. So their federally assisted housing provider would then pay for the construction of the ramp as a reasonable modification to the tenant's disability. So again, this is for federally assisted housing, whereas in private rental market, if a person would need a wheelchair and a ramp to be installed, they could then make the modification request, but the housing provider would not be obligated to pay for it. Okay. So now I'm just going to quickly round us out in a conclusion, so I can give it over to Mara and Beth. Thanks for sticking around with us here. So who is liable? This list is not exhaustive. Just about anyone. But developers, architects, builders, engineers, landscape architects, contractors, corporate owners, homeowner associations. The list can go on and on about who is liable. And what are the consequences? So of violating the laws, right? Again, lawsuit or complaint investigation. If the probable cause is found, then it could go to an administrative hearing. And then damages could be awarded, which might include compensatory damages, punitive damages, injunctive or equitable relief, and then even could lead to, suspension or loss of a person's real estate license if they are somehow involved in discriminatory acts when it comes to the fair housing law. So some quick resources. Again, I know this was a very brief summary of some really intense and in-depth information. So what a resource that is godsend is the Fair Housing Accessibility First initiative. And this is an initiative that's designed to promote compliance with the Fair Housing Act design and construction requirements, and has an extensive amount of resources, trainings. Again, just the accessibility guidelines could be a full day training on its own. So if you are interested in more information, I would suggest that you go to the Fair Housing Accessibility First initiative website for more information. Furthermore, the Fair Housing Act Design Manual and the Fair Housing Accessibility Guidelines. So in conclusion, just a couple points to kind of wrap it all up. We talked about history, applicable laws, covered property, protected classes, what acts are considered to be discriminatory, and then we took a deep dive into additional protections for persons with disabilities. So in conclusion, one thing to note is that, while state and local laws may contain accessibility requirements that meet the standards of the FHA, you can't just specifically just rely on the state and local laws, right? You want to still ensure that you are looking at the guidelines to ensure that you are meeting requirements, or the safe harbors, the guidelines and the safe harbors to ensure that you are meeting the guideline requirements. And then I can't emphasize this enough, the new construction requirements provide the minimum accessibility standards. So, additional accessibility features should be considered. A home of one's own, whether rented or owned, is one of the cornerstones of independence for people with disabilities. And when we do these presentations or when we talk about accessibility, we also have to do it in the context of remembering that accessibility benefits everyone, right? In those 7 accessibility features, I talked a lot about it, referencing a person in a wheelchair. But if something is accessible for a person in a wheelchair, it's also accessible for a parent using a stroller, also accessible for an aging person with some mobility impairment. So, accessibility features are beneficial to everyone. And with that, I will conclude. If you are interested in getting more involved with the Fair Housing Center for Rights and Research, you can follow us on social media, call us with any questions, refer individuals to us for assistance, and then also continuously spread the word about fair housing rights.
Thank you so much, Tanisha. Seeing no other questions, we're going to move on to Maximum Accessible Housing's presentation.
Hi, thanks so much for having us tonight, and wonderful presentation, Tanisha. You really set us up well to begin our presentation here. There we go. We have our captioning on the bottom. If anybody needs that, it's at the bottom of our slides. So we are really excited to be here tonight. Tanisha did a really wonderful job of setting up this presentation. This one is going to give a little bit more context to what exactly the definition of disability can spread to, can be incorporated as, and then we're also going to talk about and see some examples of going beyond the ADA, going beyond 504, those federally mandated requirements and measurements for home modifications, home builds, and really seeing in a very practical sense in real life applications how we can go beyond that and how that can benefit everybody. So let's just jump right in. And my name, by the way, is Mara Lane, and I'm here as well with our Vice President of Maximum Accessible Housing of Ohio, Beth Glass, and Beth will be jumping in to provide a little bit more context if needed, as well as answer any of the questions that you might have with her expertise. So let's jump right in. Let's talk about housing. So Maximum Accessible Housing of Ohio is our organization. We have had, we've provided accessible housing for the last 40 plus years through our Vistas apartments, which are fully accessible HUD subsidized housing. And through that, we've been able to learn a lot about going beyond the ADA. Of course, they're fully compliant with HUD's requirements for this housing, but it also expands to be a much more inclusive environment to a plethora of disabilities and not just a general blanket for, as surface level as we can get for disabilities in general. So we want to make sure that we are really stressing that this is going to go beyond that, just those first requirements. So the housing that we currently have is built for the majority needs. So that's going to be able-bodied people with money. There is a 25% chance that a home will have a resident who needs full accessibility. And the Joint Center for Housing Studies from Harvard University has some really, really great reports on housing in communities. From there, we learn that less than 10% of existing homes are considered to be accessible, and about 35% of those homes are considered, and about 35% of homes are considered modifiable. In 2038, about 17.5 million households will be headed by somebody who is 80 years old or older. And that is a 2% increase, or sorry, a 12% increase from what we are currently experiencing. It usually goes up about 10% each decade or each round that these studies go on. So that additional 2%, if you can imagine it, is about the size of Cleveland. So about 300,000 people will be in need of accessible homes. And less than 10% of those existing homes will be accessible. So if every single person who needed an accessible home had one, there would still be 300,000 people who did not have an accessible home. And that's just wishful thinking, right? And we also want to go ahead and note that just 1% of rental housing units are considered to be accessible. So basic access includes at least one no-stop entry, bathroom, and a usable bedroom on the main level, wide doorways and hallways, high outlets, low switches, and lever handles on doors and faucets. And we can all look around in our own housing today. I live in a rental apartment, and I have literally none of those features in my house. I actually live on the 3rd floor that I have to walk up to. So I myself can attest that I do not live in accessible housing and have never lived in accessible housing. We also want to note that the laws and regulations that we do have, again, are having minimal impact in increasing that accessibility. Only about 6% of units in buildings that were built after 2003 are accessible, and only about 11% of units in those buildings, and only about 11% of units in buildings with 20 or more units. So a very, very small percentage. We also want to just really make sure that we mention that fully accessible means being able to complete daily living tasks as independently as possible and preferred. And we're going to see now some comparison pictures between two units. One was built in 2015 as an ADA accessible unit, and a lower income unit in a mixed use building or mixed income building. And the other was built in 2013 as a fully accessible and low income unit in one of our Section 202 subsidized buildings. So we're going to take a look at that now. So the first thing I want to start off with is noticing the differences between these kitchens. For one, you can see that the footprint of this kitchen is much larger. While there may not be any barriers behind within this, and it's just this one stretch of kitchen in our ADA accessible unit, you can also notice that there's a lot less usable space than there is in this fully accessible unit. Here we have countertops at different heights, which will account for people either sitting at different levels in a wheelchair or standing at different heights, whether they are small, short in stature, or taller. There is usable space for all of them to be in the kitchen working at the same time. We also have much higher cabinets in this kitchen, much lower in the fully accessible kitchen. These cabinets are probably at a very standard height. Just whatever the contractors had been putting in for all of them, probably just barely meets the ADA requirement. Here we're having them much lower, which yes, will give you a little bit less of that usable room height-wise on the kitchen counter, but we'll also see a lot of these cabinets actually being used rather than things being stored in lower cabinets or off to the side here. Also much more options of usable storage. Here we can see that there are usable outlets, whereas that are right underneath the cabinetry, which you can reach from a seated position next to the counter. Here, one would have to hoist themselves up and over the counter to reach an outlet at the back. We can also see, again, as Tanisha pointed out, these differences between the available appliances. These appliances, while probably very similar in age and price range, are very different in usability. So here we can see there are front controls as well as a front screen, no leaning over necessary. And here you can see all of those controls are on the back of the range, meaning that this oven is actually completely unusable and unsafe for anybody seated in a wheelchair. I believe that the person who was in this ADA accessible quote unquote unit on the left actually had to use a hot plate for the majority of their cooking. No?
They were actually able to get, as a reasonable accommodation, the property owner moved that oven out before the tenant moved in, and they had to provide their own oven. So for somebody with fixed income, having to spend $500 on an oven for a rental unit, and that was the agreed upon an only possible accommodation in that case. He did have to add in his own storage because he couldn't reach any of the upper storage. So again, had to purchase and add in storage units to put in that. Mara showed in the first image the limited floor plan there. The little bit of space that he had to fill with additional storage.
Which is just, and that's on behalf of having a lot of advocacy on his behalf also while going through that housing process, right? So he wasn't even alone while having to make these modifications and accommodations, just having advocates with him, and that's what they were able to accomplish. So you can see already a taste of the inequity that we are trying to navigate around by having these fully accessible apartments available rather than just the ADA accessible apartments. When we move into the bathroom right away, I want to have us notice the roll-in features of the shower here. This is the ADA accessible unit. Again, we have a built-in bench, which is very far away from the shower head. So if one were to need this bench, they would not be able to use it unless they were using just the handheld shower head. While if somebody did not need this bench, they also would have then the floor plan of this shower limited by this folding bench here. They would have to put in their own shower bench or put in a roll-in wheelchair minus this extra square foot of space here. Here in this fully accessible unit, we can see that there is a fully open shower. This is called a wet bath, I believe, where there are 2 drains. The entire room can get wet and not be damaged. And again, like people always ask if there's no floor, if there's no edge for the water to get, for the water to be kind of dammed in by that edge. Won't water go everywhere? We can assure you that unless somebody gets a little wild with a shower head, the water can go straight into the drain. And there's also, it's very flexible, total flexibility for anybody to wheel their wheelchair in or out or have a shower chair if they need. Here we can take a look at the toilet. You can see, maybe you can see, we just have the one grab bar here, which perhaps there is blocking behind this toilet for additional grab bars to be added in if and when necessary. But again, those are probably modifications that would need to be made out of pocket. We also can see that the closed side of the toilet is where the flush is located, which in addition to being inaccessible, somebody would have to lean over the toilet to be able to flush it, and that's not always a possibility, is also just against housing code. And this is again in an ADA accessible unit. And here we can see the difference between the sink space. So here there is very minimal roll under sink space. Anybody in a wheelchair would not be able to have their knees underneath there. In addition, there is this extra ledge because of this pedestal sink. You'd have to reach up and over that ledge in order to access this faucet here. And the mirror space is very high up. This lighting element here actually would obscure any bit of the mirror that somebody seated would be able to see themselves in. Here we can see a completely open underneath of the sink. We have covered pipes to make sure that anybody's knees who might hit the pipes will stay safe because of water temperature. We have no ledge obscuring the faucet, and we have a mirror that goes all the way down to that backsplash. So again, just that difference there. Here, a very simple difference. We want to make sure that we're noticing that fresh air is a human need, right? This apartment actually had very, very little space and light, especially windows in it. And the windows that were available looked into the building, like onto a roof platform into the building. So not even out onto a street or anything. Here, all these windows are outward facing and have crank windows as well. So people are able to enjoy fresh air without having to lift up a heavy window. They can be cranked instead and use that. Here we have differences in our flooring. We have a padded carpet, as you can see, and a flat, almost like pork lake floor. Here in this transition strip, you can see that it is bolted down and it's also very thin. This transition strip is there solely to keep the carpeting down and not have it pop up, although we have seen a lot of these bolted down thresholds or transition strips over thresholds between these types of flooring pop up over time. I, in my own apartment, see my transition strip will pop up. It's metal as well. And wheelchair wheels can get snagged on that, feet can get snagged on that, as well as on padded carpeting. It is very difficult to have any kind of movement of wheels, whether it's a walker, a cane, an ambulator, a wheelchair. It's very difficult to move on padded carpet. Here we have completely unpadded, low pile carpet with a rubber transition strip that makes a very smooth, long transition onto this similarly leveled flooring as well.
To Mara's point about that carpet, the person who lived in this unit, he was unable to use his manual wheelchair because the carpet was so thick. And so he had to use like forearm crutches and basically drag the lower half of his body and crawl in order to use his bedroom, simply because of the carpet choice. So a grown adult being forced to crawl through his bedroom because of a carpet choice and a unit designed to be accessible.
But again, totally within compliance of the law. So, and again, does that mean that he's then going to have a reasonable modification and pay for all brand new carpeting, again, on that limited income? Probably not. It could put extra stress on his body. It could lead to medical issues down the road. All of this just because we didn't think to change out the padding underneath the carpet or change out the carpet to a low pile carpet, which I have heard is much easier to clean than a high pile carpet.
Or just no carpet at all.
No
That's
carpet
also
at
an
all is
option.
also great. And here, again, a basic human need, which is clean clothes. We all need them. This apartment complex wanted to save on space, which is totally fine. But they chose a washer dryer that could have been accessible had this been quite a bit shorter, or the controls for it been placed on the bottom. But instead, the controls were placed at the very top, completely inaccessible to somebody who is is seated or maybe needs both of their arms for balance purposes while standing. So we want to make sure that if we are going to be choosing appliances, that they are at a usable level. These are just as great machines, if not better, because they're much larger and they are for public use within this building, this fully accessible unit. I also want to note that the lights in this little laundry area are also on a sensor. So if they sense movement, they will turn on, which eliminates another barrier for people with disabilities for having to turn on a light switch or locate a light switch if they have low vision. Something I do like here is this outlet is much higher than I would see in a normal apartment, but much lower than the outlets that you would see in this fully accessible unit. We also want to mention one more thing, which is this open door here. This door is always open if there's even a door there. Beth, I can't remember if there's even a door. Yeah, there is a door, but it's always propped open. And this door is a sliding door, which can be very difficult to navigate if you are seated, having to push one out of the way, or if you have limited grasp in your hands. Using this very small handle here can be difficult. Again, if you have any kind of sight-related disability, locating even that handle could be a challenge itself. Go ahead, Beth.
Just a couple things I also wanted to point out. In the common laundry room here, which you often see in multifamily buildings, we intentionally built in these windows, not for an accessibility reason, but for safety. Because imagine if there were no windows there, somebody could easily kind of sneak up on you if you were doing the laundry and your back was turned. But also in terms of accessibility, you don't have to go all the way into the room to see if the machines are in use. You can just walk by and see through the window. So both safety and ease of use. And Mara pointed out the outlet in the ADA unit picture. And earlier, Tanisha spoke about the ADA design standard for an outlet being at 15 inches. That's actually like pretty low in terms of somebody using it seated. We recommend 18 inches as the minimum. And in our buildings, we actually put them at 21 inches, which might look a little odd at first, but you get used to it and you love it the first time you have to plug in a vacuum. or any other appliance like that, or reach one behind a piece of furniture.
Yes, I can personally attest having to plug in a laptop really quickly, being able to see those right at about eye level when you're sitting down are just incredible, or right below eye level. Oops, here we go. Sorry about that. Okay, so we've seen quite a few differences, quite a few changes from the ADA accessible to the fully accessible. So what can we do to make sure that any future builds or any builds that are currently being renovated include these accessibility tenets? Well, the first thing that we can think of to do is to survey the residents and property managers. In particular, of course, your residents who are either long-term or are seniors or people with disabilities, and the property managers who are often making these changes, making these accommodations, they'll have known what has been the most common. Potentially, they can also provide guidance on what should be built in so that incurring those extra expenses and extra work orders, extra hours for property maintenance staff can be kept to a minimum by already including these things in planning through these surveys. We also want to commit to going beyond these regulations. So now that we know the regulations, thanks to Tanisha, we've studied the ADA, we've studied 504, we know what's expected of us, both federally, but also locally. We want to commit to going beyond those. And how can we find out what going beyond those means? Well, a really big option that you have is, again, talking to the people with disabilities in your area. There's also experts like Beth and myself who have kind of boiled a lot of these features down to a science of what is best practice and what's going even beyond best practice. Work with planning and design commissions to establish these guidelines. So if this is something that you're planning for a larger move, having this become a part of the governance responsibility, encouraging this from a grassroots position, not just the people advocating for themselves on a case-by-case basis, but the government or the local city council, local planning groups advocating for these people preemptively and including them in those plans, again, is going to be best practice. And communicating expectations to developers, architects, designers, and property owners. A lot of this is lack of context, lack of education, and again, just kind of doing what has always been done. Like Beth said, the ADA says 15 inches. Contractors are used to maybe even 12, which is even lower. And a contractor might not understand why moving that outlet up from 15 to 21 would be beneficial to everybody. And the people doing the people actually doing the work are going to have a huge impact on the expectations that have been set, even to the people who are giving them those instructions. I think maybe that was a little bit confusing. To summarize that point, just making sure the people who are going to be hiring the people doing the work are really communicating clearly what is expected of them as they do that actual work. And last but not least, I've said it 6 times already, include people with disabilities and seniors in planning. 1 in 3 people in Cuyahoga County, I believe, will be over the age of 60 in the next 10 years. So we want to make sure that one of the majorities of our population will be able to use the housing stock that we currently have and is currently right now being built for 10 years down the line. We want it to still exist and we want it to be effective and efficient. And then market those accessible units and features to people who need them. A lot of time we hear from people that their housing would never sell if they made these modifications, or it would never be given a chance on the market. It wouldn't give back the return that you invested into it. We have never seen that to be the case. In fact, we've often seen people more often than not asking for those accommodations, whether they need them right now or expecting to need them in the very near future, as they're kind of moving, thinking about aging in place or gaining a new disability. We've mentioned, and Tanisha's mentioned, and it's all over the place, that we are in the middle of a mass disabling event. And people are aware of that. People are aware of the differences in their bodies and knowing that they need extra accommodations as they age. So we want to make sure that we are marketing to that demographic and really getting that return on their investment. So now we're going to take a few minutes to look at some examples in our public spaces in the community. And we want to make sure that we're touching on a few really important items. So one, just like our housing, our communities are built for the needs of the majority, which again are going to be able-bodied young people with money. Businesses in particular tend to focus on attracting potential customers that are younger or more able-bodied, young families or millennials, Gen Z, people that they anticipate don't have any disabilities and have a lot of disposable income, when that's not necessarily the case, especially here in Cleveland. And often in public spaces, there is a perceived fight between aesthetics and access. Why? I don't know. I've seen lots of beautiful, accessible places, but there's this perceived fight going on. There are, steps leading up to buildings that are perceived as getting its status. We see a lot of our homes, especially in Shaker Heights, you'll see a lot of those homes up on a pedestal or that kind of yard that leads up to a grand porch that has steps leading up to it. But in reality, those steps, whether they're up to our home porch or up to a business, up to City Hall, those steps are just excluding people in wheelchairs, people with knee or back pain, children in strollers, and yes, even our Amazon and UPS delivery person. And again, laws and regulations have had a very limited impact. Granted, it has been greater in public spaces than it has been in housing, probably because of a lot of reasons, but one is that public spaces are subject to a lot more turnover and a lot more visitors, right, than our homes. And so we want to just note some really quick things. So the ADA, of course, is awesome, but it does not guarantee full accessibility. There is also just a ton of examples. We're going to go through a few of where the ADA has fully been shoved away or left in the name of progress in other spaces, particularly spaces where white, young, attractive, affluent people live, right? And the best design can be marred by later additions. So we're going to see a couple of very temporary disabilities, very temporary barriers to inclusion and access in the photos that we're going to see right now. But it's really important to understand before we look at those pictures that access also doesn't mean inclusive or equitable. So I think this first picture will give us a good example of that. Let's see here. Okay, so our first example that we have here is a sidewalk. So our sidewalk is free and clear and open here. This is in University Circle. In the University Circle area on Euclid. And we want to make sure that we have lots of these potential barriers that are actually pushed out of the way. We have lots of open room and space here. These parking meters, which would be, included as like services because of the government here, are fully accessible. We can reach them from a seated position. People standing can also reach them. They're very clearly marked. Whether they're maintained or not, again, will include access. But people, more than one, people in a wheelchair and a friend walking next to them can all move down at the same pace into the buildings at the same rate, and they can all enter through the same entrance. Here we see a sidewalk in Ohio City. This sidewalk is just full of permanent barriers, but also has one very important, very, very temporary barrier. This scooter here is actually acting as a complete barrier to moving down the sidewalk. If somebody in a wheelchair or with a walker or even a stroller wanted to move down this sidewalk, they could not. They would be stopped right here. Why? Because if they don't have the strength to move this scooter out of the way, then they would just have to turn around and go back until they found a curb cut. This is a pretty steep curb here. So while you or I could maybe jump off of this curb and jump back on, having walked around it, not everybody has that capability. As well as people with vision disabilities, navigating this would be extremely hard, extremely hard. There are barriers where one would not expect a barrier to be here. Part of that is because of this expanding landscape for seating, but it's also just due to the fact that this is an older sidewalk that has been renovated without people with disabilities in mind. And that's very clear and evident here. I mean, these bricks are very new. And yet still, we don't have any room for people with disabilities. Here we can see an ADA compliant entrance. So although now part of me kind of wants to go and visit and see if this door is unlocked, because if it's not unlocked in the same way that this one is unlocked, it may not be accessible. Yes, Beth?
It is not. You have to like request access.
And is this door unlocked?
It is. During business hours, last time I checked, the side door was locked. The front door was not. After business hours, both are debit card access only.
So there is an example of inequity in action. People with disabilities have to go through a sort of shameful looking entrance, right? They have to go through like the band's entrance or the delivery man's entrance here on the side.
And
go ahead.
I'm sorry, what bugs me the most is, in the front entrance, the handrails are painted black. You can see them, there's color contrast, but the accessible entrance, they painted them the same color as the wall. So they fade in like it's something shameful to have a ramp. That's what it says.
Exactly. And if you and a friend both need you decide you need cash, your friend can just hop right up these stairs. Meanwhile, you have to go on a whole extended trip. It's actually more work to get to the accessible entrance than if they had maybe just wrapped this ramp around the side building and everybody could go in the same way. Unfortunately, this person is stuck going off here. I also see a little bit of a violation here against the ADA with this very kind of scary railing that might just send somebody right off the edge there if they weren't paying good enough attention. Here, this is ADA compliant and inclusive design, although not entirely perfect, right? Nothing is going to be perfect because humans are the ones designing this and we're not computers. We can't figure it all out. So here we have another bank entrance. This one has a much wider door available than either of these two. It is marked with an accessible entrance sign, although it could be a little bit bigger. We have handles at an appropriate height. We can all enter through the same way. We don't need to ask for any special assistance. And if somebody has a wider wheelchair or say like a 2 or 3-seater stroller, perhaps, maybe a package that is extra wide coming into this bank, they can ask for this kind of accessory door here to be opened from the inside as well, to have this nice wide open door. Now, if it was perfect, the whole thing would just open right away. Maybe we'll have a much bigger accessible entrance button here, automatic door opener here, that's much more visible with signage pointing to it. That's very clear and not so far away from the door, but again, much more inclusive. Everybody can go up this beautiful kind of Art Deco era ramp that was installed back before people even cared about ramps. And we can all enter the same way. Here we're going to take a great look at some of Cleveland's finest infrastructure here. Here is on, I believe, Case's campus. Yes, Beth, on the better side? I believe Case's campus.
I think those are both in Ohio City, like not far away from each other.
So while we have some of these maybe more frequented intersections kind of nicely painted, you can see we have a brand new curb cut, although again, it's not perfect. We could, maybe slip off the side into this grate here. We have a nice flat landing available for us when we get up there. We have very clear lines. Maybe in the future, we would even have a walk signal that we could press because there's a lot of traffic and a lot of accidents that happen even to pedestrians in the Ohio City neighborhood. It's very well known for having tons of traffic accidents. Meanwhile, this is also a pedestrian intersection. And it has just been entirely neglected. I would say, judging by the look of this, probably it has not been updated for at least 20 years, if that. And so why is this getting this update? Well, this one is being left alone, being left to the people who are navigating this space to figure out a different way for themselves. I don't know. You can also see in the shadow here that there is most likely a large vehicle parked right here on this edge of this corner, which is completely blocking what little remains of our crosswalk that would have been there to allow people off the sidewalk. So temporary barriers, but also permanent barriers, both existing, both creating this compound barrier to inclusion, to be able to just navigate your neighborhood, walk around your neighborhood, which is so incredibly sad because we have all these resources, but if you can't access them, then they're not inclusive and they're not ultimately accessible. So I've shown you all the sad things and also some things that are a little bit better, a little bit more improved, a little bit more thoughtful. And coming from a place of humanity, right? But what can we do to include these thoughts in our future as we go along, creating this new infrastructure, creating this new housing? We can do walking tours in our community to with an eye to inclusion, equity, and usability. We really want to make sure that our resources that we do have available are actually usable. And Beth and I actually do a program called the Mobility Experience, where we often take thought leaders, government officials, and business owners, architects, etc., on tours of their neighborhoods and buildings using mobility devices themselves. So you might think that your constituency is experiencing a very accessible community because you yourself had no problems walking around it. Meanwhile, the seniors and people with disabilities, young parents in the area are actually struggling, and you can experience that. Take out your stroller, take out your grandma with her walker or her wheelchair, and just see how she does. Or contact us, we'd be happy to help. You can also check out AARP's Livability Index. Some of the facts and figures we shared here tonight will actually came from AARP's Livable Index, but it also can tell you a lot about where you particularly live. And I believe that it's self-reported from seniors in the area. Is that true, Beth?
Not entirely, because it also looks at things like proximity to hospitals, bus stops, senior centers, community centers, all sorts of things that are factors in how easy it is to live in a neighborhood.
Absolutely. And we know for a fact that it's not just seniors who are going to look at this AARP livability index. It's also going to be people with disabilities and even young people who are looking to buy their forever home. The idea of buying multiple homes in a lifetime is becoming more and more sparse for younger and younger generations. So to make sure that your community is in good standing with this AARP livability index, I would make sure that you took a peek at that to see where you're standing right now. Work with planning and design commissions, again, to establish those guidelines. We need to start, we need to continue taking on the responsibility as these organizations and governments to make sure that we are the ones who are really, leading the sleigh on this. We want to make sure that as a little Santa Claus reference for the holiday season, I guess. We really want to make sure that we are leading the charge on this and not putting the burden again on those people with disabilities to advocate for themselves. We want to make sure that we are listening and then putting all of their ideas and needs and wants into action. And we want to, and also when you are creating those planning and design commissions, think about including people with disabilities on those commissions as well. And communicate expectations with businesses, developers, and designers. One of the best things that you can do is offer a free service to a local business, right? Local businesses are oftentimes, really struggling, especially now during the pandemic with the economy kind of having a little bit of turmoil right now. Local businesses can use all the support they can get, and a lot of people want more customer bases. They want more people to be able to use the land that they're developing, the condos they're developing, the spaces that they're designing. They want people to be able to use them because that's just good for their pocket and for their investment again. So we want to make sure that we are communicating those expectations to them through these education campaigns, through these laws that we're going to be passing or deciding on with the community so that they are able to benefit from them. And practice inclusive planning. Again, we're just going to make sure that we are including people with disabilities, seniors, community members in everything that we're doing. Why? So that not just so that they are involved in the process and that we can get their expertise, but also so when somebody asks, why is this the way it is? We have the answer, which is because we listened to you. We listened to the people. This was your idea and we put it into practice. And that's just, generally good practice, but also is a really good way to create and cultivate an inclusive community. People can look around and say, I had that impact. So what are some resources that you can reach out to, make sure that you have available to you? Mayho, Beth, and myself are always available for consultation. We have a couple services like our ADA Plus assessments, wherein we go and do assessments to make sure things are up to code with the ADA, and then we give ideas and suggestions of how to make it beyond the ADA to really get to that point of being inclusive. We also have independent living centers. I know that there is a great relationship here with Shaker and with the Fair Housing Center with services for independent living, which is over on the east side. There's also LEAP, which is over on the west side. That's LEAP, LEAP. But they're all over the state. Area agencies on aging, ours is the Western Reserve Area Agency on Aging, and they always have tons of trainings and classes available as well as resources. Senior centers, again, a really great place to understand your demographic, a great place to see what people are interested in and what people want to learn and share. And then other nonprofits and agencies serving people with disabilities and seniors. I would love to open up for any questions or discussion. And if there is none, you can always reach out to Beth and myself. Our email and phone is up there on the screen. Beth, any closing kind of remarks?
No, thank you so much for listening to us and for even just being here tonight. This is more of an art than a science, and we know it takes a lot of effort to get all those details right, but it means so much. The difference between being able to get into, a bank by yourself or with your family is a huge deal for somebody.
Absolutely. Okay, so I'm going to stop sharing here. If there's any more questions, we'd be happy to answer them.
So just a couple of questions I received. And I'm going to, either of you can answer this. Tanisha, in your presentation, you had said that if a person is going to make a request for a reasonable modification, typically the tenant is the one who has to shoulder the burden of paying for that modification. You did discuss about tenants who receive a voucher, for instance, and that person who likely is low income would still have to shoulder the burden of paying for a modification, but it's subsidized housing, right? Because they're low income. So I'm just wondering if any of you have any suggestions for resources for persons on a limited budget who may need to request a modification knowing they have to pay for it.
Absolutely. Sorry, I got really excited. There's lots of resources for tons of different types of modifications. Beth, Tanisha, please feel free to jump in. Depending on the kind of modification that you need, whether it is the install or the actual appliance or grab bar, any kind of piece of equipment that you might need, going to those resources on our list and asking if there are any available donations is always a great first step, especially if it's not something that you feel comfortable purchasing firsthand. Other great resources are the Restore, thrift stores, even medical supply stores are all really great places to find those pieces of equipment. When it comes to install, Tanisha, Beth, you might have a little bit more knowledge on that front.
So thank you, Mara. Those were absolutely great resources for if you need to purchase. I don't, however, have any extended knowledge about resources for installs. And I don't know, Beth, if you might. Okay.
It's hard. So I don't, because that's going to cost money. And most programs that do help with finances like that, it's for owner occupied units. There is one program in the county that will do it for rental units, and I cannot think of what it's called. I will look that up and send it to Lisa to follow up with you guys. But there is one program that will help, but I believe the cost has to be like $3,000. It might actually be the help loan from the county, but like if that's for a larger project. So if it's a smaller project, like most of the stuff that you would do in an apartment would be less than $3,000, except maybe like something big, like a roll-in shower.
One more resource that I forgot to mention, and I don't recommend this for just the apartment tenant themselves, but any social worker or social service agency who might be acting on behalf of that tenant might want to connect with their local realtors who might have access to modifications that people are giving away after either selling their home, or especially after Medicaid buyouts of homes. Often happens when seniors pass away. Their Medicaid will often continue services on the equity of their home. And so a lot of those appliances and fixtures need to be taken out of the home before, I think it's 30 days, maybe longer. I'm not an expert on Medicaid at all. But a lot of times those homes will then be sold by a realtor who is looking for those pieces of equipment to be taken out before a new person moves in. So if you are a social worker, that might be a resource for you. I recommend getting to know your local realtor.
One other question. What would any of you suggest to perhaps, let's say you had a homeowner and maybe they're having elderly parent move in with them, or maybe this couple is thinking long-term and they're going to be doing maybe a renovation, maybe on their rec room or their great room. And they're thinking about perhaps they might want to incorporate some sort of accessible features. What advice would you have for that situation?
Contact us and we can come over and do a home assessment and give some really specific advice and talk about your current and future accessibility needs.
Absolutely.
Or you can call us and we can talk on the phone about it. Other good places to start would be, Mara mentioned AARP on their livable communities section. They have HomeFit. Their HomeFit guide is a nice place to start. That gives really easy to consume tips on some different things, and they focus on different areas too of the home, but also different medical conditions that you're looking to address. That would be a good place to start. Mara, where else? What do you think?
One of the biggest things that I can mention is to go to your parents' current residence and watch them just live in their home for a day, see what is going on. Are they furniture surfing, which is something, which is a term that means like holding on to furniture as they move around? If so, it might be a good idea to put in a railing in the room that they're going to be occupying. Are they, struggling to stand up after sitting? It might be a good idea to put a grab bar in, even in an unconventional place, like next to their favorite reading chair. And then beyond ARP and and WRAAA here in Cleveland, reaching out to, again, those independent living centers to try out equipment. Oftentimes they have things that you can borrow for a very short period of time to see if it would be helpful. And then we also have a demonstration unit in our building that is currently under construction, but if there's anything you're not sure about investing in yet, but want to see if it would be useful to that parent, bring your parent to us. We're also very persuasive. A lot of older adults don't want to make changes to their home, particularly if they spent a large part of their lives building up to, saving for that home or building that home, creating that home into a space that they really liked. Moving into a new space or altering their current space can be kind of scary. So having people who are experts in housing like Tanisha or experts in accessibility like Beth and myself can often be really reassuring that this is a really normal process.
One more question. Let's say a person wanted to, Tanisha, this is probably for you, wanted to ask their housing provider for either an accommodation or modification, and they really don't know where to start and how to go about the asking process. Do you or your website have any resources that might be useful?
Yes, we do. Absolutely. A person could, of course, give us a call, and one of our advocates could walk that person through that writing for that request. Or if you take a look at our website, we even have one available here. We have a great guide that is available in Spanish, Arabic, traditional and modified Chinese for accessible housing for persons with disabilities. And in this guide, we have some example letters that individuals can use to tailor to make a reasonable accommodation or modification request.
Excellent. Well, we are approximately at just a little bit after 7 o'clock. On behalf of the City of Shaker Heights, thank you so much to Beth, to Mara, and of course to Tanisha for another wonderful presentation.